Welcome to the next installment in our lecture series here at Rutgers University for the American Economic History course online. And in this lecture, we are going to be taking a look at big business and in particular government intervention as it relates to big business. So this is chapter 18 in your textbook. And as a backdrop, I just want to give you a little bit of a notion of why all of this is important. First, make sure you realize that what we are talking about is the Industrial Revolution as it occurs in the United States. That we're seeing a shift from an agrarian economy to mainly production on farms, and slowly we are seeing a shift to a manufacturing-based economy. And this takes a good part of the 1800s. And by the end of the 1800s, we end up seeing companies that are very large in scale, much larger than we had ever seen in the United States. So I want you to realize that these firms, these manufacturing firms that start to exist, become larger and larger in terms of resources, capitalization, number of workers, utilized by these firms. So there's going to be an implication that we have this concentration of economic power in these large entities. There are going to be implications economy-wide in the United States, whether it's in labor markets, resource markets, export markets, etc. And we're also going to see that there's implications in pricing, that these firms are gaining more and more market power. And as they gain more and more market power, they have greater discretion over pricing, and they use that market power to their advantage. And some of these practices are frowned upon by elements of the government and of the populace. So what I want you to realize is that cause and effect, that the concentration of industry, the larger and larger scale of industry, concentrates economic power, which gives these firms discretion over pricing, i.e. gives them market power. And in response to this, individuals in the economy get upset with this concentration of power and seek government assistance in addressing the issues of this concentration of economic power. So I want you to realize that train that occurs there, increasing industrialization, increasing concentration of economic power, and the fact that we start seeing government intervention in response to these changes, this concentration in industry, particularly manufacturing in the United States. So some objectives, what you should understand about this particular period. So what were the implications of the rise of big business? As big business, as these larger scale operations started to come into existence, how did they impact the economy as a whole? Excuse me. Excuse me again. Apologies for those two sneezes. All right. So, and what was the government's response? Why did the government respond in the fashion that it responded? We want to take a particular look at the court case Munn versus Illinois and the importance of Munn versus Illinois in the economy, and in particular in regulation and governmental regulation. We'll take a look at the Intercommerce Commission, what the Intercommerce Commission's purpose is, and its role in regulation then, and has it evolved to this day. And then finally, we'll take a look at the evolution of the antitrust legislation that came about during this time period, what the major components were, and what they were attempting to address in their passage. So I want you to realize that by the 1880s, the amount of government control of the economy was minimal. So while this is occurring, while this industrialization is occurring, and we see concentration and larger firms coming into existence, there was very little governmental control over economic activity. I want you to be aware of that. Of course, that eventually changes in the 1880s, 1890s, and the early 1900s. So we don't see any of these large governmental agencies that regulate trade. For example, the Interstate Commerce Commission, any number of large governmental agencies whose job it is to regulate business. There were no antitrust laws in existence by the 1880s, no federal income tax, and no federal licensing of businesses. So I want you to realize that up until the 1880s, the footprint of government was quite small in relating to regulating economic activity. So just realize that. Of course, that eventually changes, and it changes a great deal. So I want you to be aware of the climate in the 1880s and how that evolved after that time period. Now, just because there was minimal government control over economic activities does not mean that there was no impact of government on the economy during this time period. So a lot of people make that assumption that they see that there was very little governmental intervention in the economy in the 1880s in the United States, and they take that to mean that there was no intervention. Realize that there was some level of intervention in governmental activities in the economy in the 1880s. All right, realize that. A couple of key points. The federal government controlled the public domain. Very important component. But the public lands were still under the control of the federal government and their ability to use and dispose of the land. All right. Also provide land to individuals as part of their business activities, i.e. the railroads. All right. So realize that the fact that the government provided subsidies to the railroads in the form of public domain, there was a large impact on the economy by the fact that the federal government controlled the federal domain. So they played a big role in how the railroads and where railroads were built. So realize that there was an impact there. All right, the government did have the ability to tariff. So it could place taxes on imports. So it could impact the flow of commodities into the country and create economic rents that would not have existed. So they could place a tariff on an imported good, which makes the price of that product much higher, and the individuals who are domestically producing that will become more profitable because of that tariff. So the fact that the federal government could place import taxes had an impact on the economy as a whole. Also, the federal government reorganized the banking system. In the 1860s, came up with the National Banking Act, which reorganized the system in a national banking system, switching from a system that was regulated by the states to a national banking system. So obviously, if the federal government is organizing the banking system on a national fashion, the banking system itself is going to have an impact on the economy as a whole. So the fact that the federal government is regulating banking means it has some control over economic activity on the national level. The fact that the federal government had control or some control over the money supply meant it had an influence over wages, prices, and interest rates. So that is another vehicle that the federal government could impact economic activity through the direct control or the attempt to control the money supply. That meant that they could have an impact on wages, prices, and an impact on interest rates. Also, the fact that the federal government controlled immigration policy, which controlled the flow of migrants to the United States, which controlled the supply of labor. And if you have control or some control over the supply of labor, you have some impact on wage rates. So I just want you to realize that even though many people believe, as I stated, that there was minimal government influence, federal government influence on the economy as a whole, do not confuse that to mean that the federal government had no control. All right, that the federal government did have some elements of a command economy or some elements of controlling the the economy, the economy of the United States as a whole. It just ends up that when we talk after 1880s, we end up saying the federal government ends up with a much expanded role over that previous role. All right, and what was the reaction, and why did the federal government react the way it did? If we talk about Chandler, Alfred Chandler, he is a writer of a book called The Visible Hand, little take on Adam Smith's The Invisible Hand. And he talks about the evolution of big business in the United States, and he says that these large businesses are justified because they generate economies of scale, i.e. that their larger scale of production allows them to produce items at a lower per unit cost. Their average total cost in the long run is declining as the scale of their business increases. And they got these economies of scale by a continuous production process. The fact that they did a continuous production process that was available. So for example, the assembly line was a continuous process that had economies associated with that. He also had a book called Scale and Scope, and he argued several things about the corporations that were successful during this time period. First, that these companies invested in facilities that were large enough to exploit economies of scale, i.e. they invested in a capital stock and used a mix of capital and labor that allowed them to minimize their cost, to produce at a lower per unit cost. So they invested in the infrastructure that allowed them, and invested in the capital stock of the company that allowed them to reduce their costs of production. Secondly, if you have to produce a lot in order to exploit these economies of scale. You have to be able to sell those products. So these large companies also invested in a national marketing and distribution network. It means very little that if you can produce a lot of a product at a lower per unit cost. You also have to be able to sell that. So if you're going to produce a lot of items, you have to be able to market and distribute it. So you have to have a marketing and distribution network so that you are selling what you are producing. This first component is irrelevant. Just because you can invest in a capital stock and produce items at a lower per unit cost is meaningless unless you can sell them. And if you're investing in this capital stock, you're producing a large amount of output, which means you have to sell a large amount of output. Also, he points out that they also invested in human capital, i.e. management. This is where the management sector becomes very important. The fact that you have multiple portions of a company. You have individuals managing subsets. You have a managing director, an operations director, a finance director, etc. You have to invest in training those individuals on how to manage those particular entities within the corporation. So there is a subset, a skill set that is necessary to manage these large-scale operations. And Chandler argues that these corporations, particularly the successful corporations, invested in training people in order for them to be able to manage these large-scale operations. Now realize that originally the business privileges that were given out in the United States were basically exclusively through the states. And there wasn't much of an actual process. Basically, if you wanted to be incorporated as a business, you had to have a special franchise, which means that if you wanted to open up a business and have a corporation, you had to have a specific piece of legislation for every time a business opened in your state. So the state legislature would have to get together and vote to allow you to have that charter of a corporation within the boundaries of the state. So there was no process, uniform process within the state of how to incorporate. It was always by legislation that these corporations were instituted. And as you can imagine, as today versus any other day, that process was cumbersome and also very corrupt. You had to make sure that the individuals would vote for that corporation. This would entail any number of legal and illegal payments to ensure that you got that chartered corporation in the state that you needed. All right. This changes in 1811. New York actually makes provisions for the incorporation by simple registration. I can give you an example for myself. I am incorporated in the state of New Jersey. All right, all I had to do was fill out some paperwork. I didn't have to go to the state legislature and get a law passed that said that I had my own company. I just physically had to have a lawyer, work with a lawyer, fill out some paperwork, and every year I have to pay a $50 registration fee. All right, so that's the example that we're talking about in New York. There's a simple registration process, and it was further liberalized that there were restrictions on the type of businesses and some capital requirements that you had to have in order to become incorporated in the state of New Jersey. I'm sorry, in New York. So make sure you realize that initially that chartering a corporation in the United States required pieces of legislation. So every time you open up a business, a new piece of legislation had to be passed incorporating that. These started to change in the 1811. New York was one of the first to make provisions for incorporation by registration, and they further liberalized that by lifting the restrictions on the types of businesses that could be incorporated, but they also changed the capital requirements that were necessary for incorporation. 1837, Connecticut also provided for incorporation, and New Jersey eliminated all capital requirements. And it also allowed businesses to do business out of the state of New Jersey by the late 1800s. So New Jersey started to realize that these businesses were doing interstate commerce and they weren't restricted to the boundaries of the state. So their charter allowed their registration of businesses allowed them to do business across state lines. All right, here's a couple of things that are important. In particular, I want you to remember any of these court cases. In particular, just have a general understanding of what the court cases were. Mostly because these court cases make very convenient multiple choice questions on your online assessment. So I will tell you in general, anytime we talk about court cases, make sure you have a good idea, not a good idea, but what was a general overview of these court cases. So realize that in 1819, that the Supreme Court realized that corporations was an intangible being and not a constitutional citizen. That was Dartmouth College versus Woodward. And also in 1851, the court ruled that the states and the cities did not extend beyond its borders. Coley versus the Board of Wardens. All right. Also, in 1886, the Supreme Court held that the corporate person was protected by the Due Process Clause. So in Santa Clara County versus the Southern Pacific Railroad, make sure you remember that case. All right. And realize that as the Supreme Court started to rule, it took away some of the regulatory powers of the states and the cities in regulating corporations. So what was the purpose of the antitrust laws? All right, what were the aggregate causes of what was occurring with these large organizations? Always remember that economies of scale played an important role, that these organizations got larger and larger. They were able to produce large amounts of output at a much lower per unit cost. So they, in essence, in order to exploit the economies of scale, you had to be a large-scale operation. You had to produce a great amount of output. Also, declining transportation costs are also important with this. The fact that you produce a lot, if you're exploiting economies of scale, you have to sell a lot, which means you have to transport those goods to a larger and larger market in order to sell them. It is necessary for declining transportation costs to also occur, because with these declining transportation costs, the available market of these firms increases. You can ship those goods further and further distance and still make a profit. Also, what is important to this aggregation of business. Why did businesses start to become larger and larger? Number one, they exploited economies of scale, which allowed them to produce great levels of output at a much smaller per unit cost. Declining transportation costs with the development of railroads and the integration of the transportation network in the United States allowed a greater market for those goods to develop. They could ship those goods to greater areas, which increased the marketability of their product. Also, financial markets developed where these firms could borrow the large sums of money that were necessary to invest in this capital that they needed to be able to exploit economies of scale. These companies were borrowing vast amounts of money. Without a developing or developed capital market, financial markets in the United States, the loanable funds that were necessary for these companies to borrow and purchase the capital and produce those items would not be available. So these three are very important. Also realize that the liberalized state laws in terms of incorporation. It was easier and easier to incorporate through the 1800s in most of the states in the United States. So becoming an incorporated entity in the states became easier. The restrictions became less draconian. And finally, and this relates to transportation costs, the domestic market was expanding, but also international markets. You could produce things in the United States and sell them throughout the United States, but you could also sell them through Europe and through other areas of the world. So as the declining transportation costs hit, you have an expanded domestic market. You can sell to greater and greater parts of the United States, but it also opens up the possibility of exporting those goods to other continents. All right, what other causes that we're talking about with these antitrust laws? Some people argued that the economic downturns that occurred during this period were related to the greater concentration of economic power in these large corporations. All right, and this caused individuals to want to change the law in the United States in order to counteract this concentration of economic power. In particular, make sure you realize the role of farmers. Farmers during this period were not doing well, and were doing less well as the decade moved forward. And there was a lot of agitation, particularly in the Midwest, that this concentration of economic power in these large entities was being used against the farmers. So I want you to make sure that most of the agitation that occurs to try and curb the economic power of these large corporations is coming from the Midwest, particularly from farmers. So what kinds of acts were being passed? The first one, and make sure you remember 1890, the Sherman Antitrust Act is the most famous. And here is the actual quote from the Sherman Antitrust Act, and I will read it to you. Every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or within foreign nations is hereby illegal. So anything that is an attempt to restrain trade or commerce is illegal. So any contract that impinges upon trade, any contract that engages in the restraint of trade, any combination or trust. So if companies get together to try and decrease competition, restrain trade otherwise, or any type of conspiracy to restrain trade is considered illegal. So any attempt to engage and to use market power under the Antitrust Act was considered to be illegal. So when this passed, the courts launched into a career of industrial and economic management. So this gave the courts the ability, and individuals could sue, stating that a company was restraining trade and it was violating the Sherman Antitrust Act. All right? And also realize that the importance of this is once this is passed, then you end up having different laws, different court decisions that end up impacting how the economy works going forward. And that it took out of the hands of the capitalists, the entrepreneurs, it took out of their hands how economic development occurred and placed the path of economic development much more in the hands of lawyers and judges who decided what was appropriate business activity in the United States. The issue with this, and make sure you understand this, is that oftentimes lawyers and judges are very much ignorant about economics in general, and particularly how you manage a large economic entity. All right? So the fact that you had lawyers and judges making economic determinations when they had little economic training whatsoever was a central issue that many people have with the Sherman Antitrust Act, that you're asking lawyers and judges to make economic judgments when they didn't know much about economics during that time. I want you also to realize that the Act, and there were several amendments after that, made business activity, some people argue, so complex that people many times did not know if they were engaging in illegal behavior. Usually you know very well if you're engaging in illegal behavior. For example, if you kill somebody, you know that you're engaging in illegal behavior. If you steal from somebody, you know you're engaging in legal activity. All right? If you take a baseball bat to somebody's car, you know that you're engaging in illegal activity. The thing that people found difficult about the Sherman Antitrust Act is that it made very nebulous what was illegal and what was legal. So oftentimes people would often say, I had no idea what I was doing was illegal. All right, so businesses could not, for example, some of the uncertainties of the Sherman Antitrust Act. You are constrained from reducing competition, but what competition is not defined in the law. All right, so how can you be held legally liable for restraining competition when competition is never defined as part of the law? All right. So make sure you realize that was one of the major issues with what people thought about the Sherman Antitrust Act. It was kind of vague. In particular, it never defined what competition was. So how could you be guilty of restraining competition when competition is never defined? The Sherman Act, let me just go through some of the major portions of the Sherman Act. All right, it prohibits conspiracies, contracts, or combinations in the restraint of trade. All right, we already discussed that as part of that one large quote, too. Prohibits monopoly or actions tending to monopolize. So now it's illegal to be a monopoly. And it's also illegal that if you attempt to become a monopoly. So if you're engaging activities that moves you further away from competition, closer to a monopolist, those actions are illegal. 4, allows the Attorney General of the United States to sue companies who violate the Sherman Antitrust Act. So there's an enforcement portion of this. The Sherman Antitrust Act allows the Attorney General to institute lawsuits for companies who are seen to be violating the Sherman Antitrust Act. It allows injured individuals to bring suit and get 3 times the damages that they claim that they had. So not only does it allow the Attorney General to institute lawsuits, allows individuals to sue and to get 3 times the amount of damages that they incurred. All right, what caused us to move towards these antitrust laws? All right, these large firms exploited, excuse me again, exploited technological change, so they had economies of scale, which meant that they got larger and larger in order to minimize their average total costs. These declining transportation costs encourage growth of optimal plant size. Basically what the declining transportation costs means, that you could produce a lot and that you could ship it over larger distances, i.e. you would have a much larger market with which to sell your product. And also, Remember that the importance of the financial markets. These firms had to borrow large amounts of money. Without an established or developed financial markets producing type of savings that was necessary for these companies to borrow, they would have never been able to finance the scale of operations that were necessary. So I want you to make sure that if you're ever asked about what led these companies to get to be so large, make sure you remember the economies of scale. Make sure you remember the declining opportunity costs, which opened up markets to them. Also the fact that they developed marketing and distribution networks in order to sell that product. And the fact that the financial markets in the United States had matured to the point where these large firms were able to borrow the money necessary to build these large firms. And these, again, this is just rehashing some of the points I talked about: the liberalization of corporation laws, domestic and international markets. And also make sure you realize that these economic downturns produced price wars that led to collusion. Realize that these firms ended up engaging in price wars, continually cutting prices with one another, to a disastrous effect on the economy and to the industry as a whole. Firms would start losing money, and instead of losing money, they decided to get together and agree with one another that they wouldn't cut pricing. They would agree on pricing, or they would cut markets up between them and distribute them. They wouldn't compete in certain markets. The Clayton Act. This is a further evolution of antitrust policy in the United States. Remember the major components of the Clayton Act. All right, forbids price discrimination. All right, price discrimination being charging different prices to different individuals that don't reflect different costs. All right, Section 3. Outlaws exclusive dealing and tying of contracts that reduce competition. So you could have exclusivity deals with one another, or you could have tie-in sales, where a tie-in sale would be, for example, in order to buy product A, you have to buy product B also. The important thing with the Clayton Act is to remember that it declares unions not a commodity of commerce, so they are exempt from the Sherman Act. Under the Sherman Act, some people started to sue unions saying they violated the Sherman Act. And what the Clayton Act addresses that issue and says that unions are not a commodity of commerce, that they are exempt from the Sherman Act, Sherman Antitrust Act. Also, it prohibits mergers, any mergers that reduce competition. Nowadays, we also see that, if the national airlines want to merge together, etc., they have to do an analysis to see how that would impact competition. So it prohibits mergers that would reduce competition. All right, and it also forbids interlocking directorates between competitive firms. What this does is it makes it more difficult for firms to collude with one another. If you have these interlocking directorates, in essence what you end up having is these directorates are controlling competing firms, and it makes it easier for them to collude in order to fix prices.